So this is the car that I told you I want to sell it. I want to sell it, but to be honest, I think I want to sell it to you. So, are you interested?
Yeah, I'm interested to buy this car, but to say that I have no cash.
It's okay. I'll give you time. I will give you this car, but the name of this car is on my name until you pay. It's like that.
So, deal?
Deal.
I think I want to sell this Porsche to someone else. Might as well bless an advertisement for it.
Wow, this advertisement is kind of good. Porsche? I might give it a call.
Hello?
Hello? I saw your advertisement that you're trying to sell your car. Porsche, is it?
Yes, I want to try it out. Tomorrow afternoon.
Afternoon. Okay, that will do. See you tomorrow then. Bye. I'm sorry, I'm a bit late.
Okay. So this is a contract inside here.
Okay. Okay. Thank you very much.
Thank you. So from today, I will explain the question. Sully and Jeffrey are best friends. Sully sold his Porsche Cayenne car to Jeffrey for 350,000 ringgit. Jeffrey agreed to pay the full payment by way of check. While waiting for the check to be cleared, Sully agreed to give possession of the car to Jeffrey. Both agreed that the title would pass after the check was honored. Sully later discovered that the check was dishonored and wished to resign the contract. To his surprise, Jeffrey had sold the car to Anna, an innocent purchaser. Sully now wants to recover the car from Anna. Advice Sully as to his right. So based on this question, we can now identify the issue. Let me explain the two main legal issues involved in this case. First issue, whether Anna acquired valid ownership or legal title of the Porsche after buying from Jeffrey. This issue comes up because Jeffrey sold the car to Anna before he actually became the legal owner. Even though Anna is considered an innocent buyer, we have to ask, can someone like Jeffrey, who doesn't yet have ownership, legally transfer that ownership to someone else? Move to the second issue, whether Sully can recover the Porsche from Anna after Jeffrey's check was dishonored. In this case, Sully and Jeffrey clearly agreed that ownership would only transfer after the check cleared. But since the check was dishonored, Sully technically never received payment. That brings up the question, does Sully still have the right to reclaim the car from Anna, even though she bought it without knowing everything was wrong?
So today I'm going to talk about the general rule, which is based on the general rule, it is fundamental that no one can give what he has not got. According to section 27, where goods are sold by a person who is not the owner thereof and who does not sell them under the authority or with the consent of the owner, the buyer acquires no better title to the goods than the seller had. This rule is enriched in the maxim nemo that quod non habet, which is no one can transfer a better title than he has himself. Thus, if goods are purchased from who is not the owner and who does not sell them under the owner's authority, the buyer does not acquire a title even if he has paid a value in good faith. The object of this rule is to protect the right of the ownership. So that is, for example, goods are stolen and subsequently sold. The right of the original owner is retained, and both the unauthorized seller and the innocent purchaser may be sued for the thought of conversion. Okay, now I'm going to talk about the example, which is according to case Lim Chui Lai versus Zeno Limited, 1964, Zeno Limited entered into an agreement with Ahmad, which is a contractor who had contracts with the PJ authority for construction of culverts. Under the contract, Zeno was to provide Ahmad with all materials for the construction. They bought the materials for the projects and delivered to them construction site. Ahmad contracts with the PJ authority were cancelled, and Zeno Limited informed them that the materials on the site belonged to them. When Zeno attempted to sell the material, they discovered that the materials has been sold by Ahmad. To be appellant, action was commended in conversion. the court decided to help Ahmad was merely the bailee and not the owner of the goods at the time. He sold them to the appellant because Ahmad had a title to the goods or authority to sell them. It follows that he could not pass any title to the appellant. Okay, now let's move to other section, which is exceptions. One is estoppel. It may arise when the owner of the goods is by his conduct precluded from denying the seller's authority to sell, which is in section 27. Other than that, the owner of the goods by his conduct makes it appear to the buyer that the person who sells the good has his authority to do so, and the buyer acts in reliance on it. The owner will estoppel from denying the seller's authority. And last but not least, the buyer who takes in good faith and for value will acquire a good title by estoppel. As for example, the case of NZ Securities and Finance versus White Cars, 1925. A is agreed to sell a car to B, and B was given a possession of the car upon the tender of a check as payment. It was agreed that property in the car was not to pass until the price has been received. B then sold the car to C and took it back on a lease. However, before the sale to C was finalized, C had contacted A's office, and in response to C's query, C was informed by A implied that B had paid for the car. The check given to A by B was dishonored, whereupon A responses the car. On discovery of the events that had occurred, C sued A for a conversion. How A was precluded from denying B's authority to sell to the title had passed to C. And last, A related the issue that of an apparent or ostensible agent who deals with goods belonging to another without authority but is deemed an agent for legal purposes. Second, for the exception is sale by mercantile agent, which is an agent may pass a good title in selling goods belonging to his principal provided he is acting within the scope of his actual authority. Likewise, if he is acting within his apparent or unusual authority, however, the mere fact that an agent is entrusted with the goods or the document of title does not of itself enabling him to make a disposition binding on his principal. Other than that, an exception to this rule is a disposition made by a mercantile agent. Mercantile agent is defined in Section 2 of the Sales Good Act as an agent having in a customary course of business as such agent, or authority either to sell goods or to consign goods, for the purpose of sale or to buy goods, or to raise money or the security of goods. As example, broker, auctioneer, dealer of goods for commission. And other than that is the operative section is the proviso to Section 27. Other than that, a number of requirements must be satisfied for the proviso to operate. First, at the time of the disposition, the mercantile agent must be in a possession of the goods or document of the title to goods. Second, the possession must be the consent of the owner. Third, the disposition must be made by when acting in the ordinary course of the business of the mercantile agent. And last but not least, the buyer must have acted in good faith and at the time of the contract of sales must not have the notice of the agent's letters of authority to sell.
Now, let's focus on the third exception, which is sale by one of joint owners. It means that goods may be jointly owned by several persons. A sale by one of the owners, not only of his share, but also that of the others, may effectively transfer title to a buyer, notwithstanding the absence of authority. Two conditions laid down in Section 28 must be met, which is, the first one is, one of the several joint owners has the sole possession of the goods by permission of the co-owners. And the second, the buyer acts in good faith, has not, at the time of the contract of sale, noticed that the seller lacks authority to sell. Exception number 4, sale under a voidable contract. According to Section 29 of the Sale of Goods Act, where the seller of goods has obtained possession thereof under a contract voidable under Section 19 or Section 20 of the Contract Acts, but the contract has not been rescinded at the time of the sale, the buyer acquires a good title to the goods provided he buys them in good faith and without notice of the seller's defect of title. Section 19 of the Contract Act refers to voidable contract caused by coercion, fraud, or misrepresentation, and Section 20 deals with undue influence, where the true owner transfers to the seller possessions of the goods through fraud or other factors that are voidable. The seller may pass a good title to a bona fide purchaser so long as the contract has not been rescinded by the true owner at the time of the sale. Exception number 5, Sale by a seller in possession after a sale. Under Section 30, subsection 1, a seller who has parted with title to the goods but remains in possession of the goods or of the documents of title can pass the good title to a bona fide buyer. The second buyer gets a good title, whereas the original buyer loses it. The latter will have to pursue his remedy against the seller. For example, a case by Pacific Motor Auctions versus Motor Credits in hire purchase, the plaintiff became owners of several cars in the possession of a dealer, and under a floor plan agreement, the dealer would retain the cars and sell them in the same way as sold other cars. Whenever a car covered by the plan was sold, the dealer would account the plaintiff for the money received. When the plaintiff discovered that the dealer was into financial difficulties, they revoked his authority to sell nevertheless. The dealer went ahead and sold a number of vehicles. Exception number 6. Sale by a buyer in a possession. According to Section 30, subsection 2, a buyer having bought goods or agreed to buy goods obtains possession of the goods or documents of title with the consent of the seller can pass a good title to an innocent demandee under any sale, pledge, or other disposition. The plaintiff sold a car to A, who paid by check, and it was agreed that title would not pass until the check was honored. A was given possession of the car, but the check was dishonored. The plaintiff then rescinded of the contract. Subsequently, A sold the car to B, who bought it without knowledge of the fact. B, in turn, resold it to the defendant. The plaintiff attempted to recover the car from the defendant.
So for issue 1, whether Anna acquires good title under Section 30, subsection 2 of the Sale of Goods Act 1957. Yes, Anna acquires good title to the Porsche under Section 30, subsection 2 of the Sales of Goods Act 1957. This section allows buyer in possession of goods with the seller consents to transfer good title to a third party who purchases in good faith and without notice of any defect. In this case, Sally gives Jeffrey possession of the Porsche under a contract of sale. Although Jeffrey checked bounds, he had lawful possession. Anna later bought the car from Jeffrey without knowing about the dishonored check. Since she acted in good faith, her title is protected under Section 30, subsection 2. This principle is supported by cases like Newton v. Lee, 1945, and also Pacific Motor Auction v. Motor Credits, 1965. Now for issue number 2, whether Silly can recover the Porsche from Anna. No, Silly cannot recover the Porsche from Anna because by handing over possession to Jeffrey, Silly has enabled him to appear as the rightful owner. Anna, as an innocent third-party purchaser, is protected under Section 30, subsection 2. Even if the contract between Silly and Jeffrey is voidable, Anna's title remains valid. The law favors protecting good faith purchaser over allowing the original owner to reclaim the goods. Silly remedy lies against Jeffrey, not Anna. So, in conclusion, Anna acquires good title to the Porsche under the exception provided in Section 30, subsection 2 of the Sales of Goods Act 1957. Since Jeffrey was in possession of the car with Silly consent, and Anna purchased it in good faith without knowledge of the dishonored check, her ownership is legally protected. Silly, having voluntarily parted with possession, cannot reclaim the car from Anna. The law prioritizes the right of innocent third-party purchaser in such circumstance, and any remedy Silly must be pursued against Jeffrey, not Anna.